Yes, Lordship. Lordship, I beg to make a mention for item 5, Lordship.
This matter was not heard.
Lordship.
Oh,
It's after a week, Lordship. After a week, Lordship, in this matter, we need some time.
on pre-made by the appellant. This is matter after 1 week.
Leo pledge, Lordship.
Costless item number 1.
May I please, Your Lordship? Your Lordship, this is a bail application under DPS Act. Your Lordship, on 12/1/2023.
May please, Lordship, before my learned friend starts, Lordship, may this matter be taken up at the end of the board. This matter was endorsed to Madam Naki Shilla, and she's still stuck in traffic jam, Lordship. Small prayer, Lordship.
Fine.
Much obliged.
Item number 2.
May it please yours.
UP. Yes,
CD was called.
who is submitting? Mr. Sinkon or Mr. Kumar?
Maybe recorded.
The case diary is being submitted by Mr. Sinkon. I will be leading the argument and Mr. Sinkon will be assisting me, Lord. My Lord.
Just a moment.
Yes, sir.
Let us go through the case diary. What does section 3 and 4 of the, was it you, no, what is UPA?
30.
Uh,
My Lord,
Ban,
13.
member of a ban organization.
No,
Is it member or
indulging in unlawful activity.
indulging?
subsequently, my Lord, 15 and 16 2 also, my Lord, added.
Yes.
Subsequently, my Lord,
Section 15 of-
and 16 2 of the UAP Act has been added, my Lord.
That you will also will find at page 516. Before your lordship goes through the case diary, my lord, may I place few facts and then your lordship may appreciate the case diary, the contents of case diary, my lord. Few provisions of UAPA Act, my lord, we have prepared a compilation regarding this issue because this issue was there as to the bar under section 43D, my lord. Section 43 in other courts also, and even before the Honorable Supreme Court, my lord. So I have prepared a small compilation. I will take your lordship to the relevant provisions of UAPA Act and the allegation FIR and the allegations and the contents relevant pages of case diary, my lord. That way, your lordship, I would be able to assist your lordship in this matter, my lord. Kindly see UAPA Act, my lord.
Yes.
And to the UAPA Act, your lordship will see 2O.
Pardon?
2O, my lord. Unlawful activities. Unlawful activity. Section 2O. Page 6 of the compilation. Compilation is, I have prepared a compilation for the sake of convenience. Please share the compilation, Mr. Sinkon, which,
Yes,
page 6, my lord. 2O. 2O. Unlawful activity. Unlawful activity in relation to an individual or association means any action taken by such individual or association, whether by committing an act or by words, either spoken or written, or by sign or by visible representation or otherwise, which is intended or supports any claim to bring about on any ground whatsoever secession of a part of territory of India or secession of a part of territory of India from Union, or which incites individual or group of individual to bring about such secession or such secession which disclaims, questions, disrupt, or is intended to disrupt the sovereignty and territorial integrity of India, or which causes or intended to cause disaffection against India. So this is the 2O defines unlawful activity, my lord, which says that if you do anything which has the effect to disrupt sovereignty or territory, this is unlawful activity. 13(1)(a), your lordship may kindly see now in the light of 13. Punishment is because the police has invoked section 13(1)(a) against the accused person, my lord.
Yes.
Now, whoever takes part in or commits or advocates, abets, advises, incites the commission of any unlawful activity shall be punishable with imprisonment for a term which may extend to 7 years and shall also be liable to be fined. Now, we are not concerned, my lord. We are concerned with 13(1)(a) and (b), my lord, because who takes part in or commits in lawful activity. And section 15, your lordship will also see kindly, because section 15 has also been invoked now. Chapter 4. Terrorist Act. Whoever does any act with the intent to threaten or likely to threaten the unity, integrity, security, economic security, sovereignty of India, or with intent to strike terror, or likely to strike terror in the people or any section of the people in India or in any foreign country by using bombs, dynamites, or other explosive substance or inflammable substance or firearm or other lethal weapon or poisonous or noxious gases or chemical or by any other substance of hazardous nature or by any other means, my lord, your lordship, of whatever nature to cause or likely to cause death or injuries to any person or persons, or loss or damage to destruction of property or disruption of any supplies or services essential to life of the community, my lord. And these are the and damage any property. So this is section 13(1)(a) and 15, both are invoked, my lord. Now kindly see the FIR, and then I will show the, and before I take your lordship to the FIR, kindly see 43D also, my lord. 43D, which
21.
43D,
Page number 21.
Yes.
page 21, and your lordship may kindly see 4. 43D 4, my lord.
Yes.
Nothing in section 438 of the code shall apply in relation to any case involving the arrest of any person accused of having committed offence punishable under this act. So 438, that is anticipatory bail provision, has been excluded if the offence is punishable under this act. 438, 4, my lord, and 5, my lord, notwithstanding anything containing no person accused of an offence punishable under chapter 4 and 6 of this act, if in custody, be released on bail on his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided such accused person shall not be released. My lord, this is for regular bail.
That is regular bail.
Regular bail. So 43D subclause 4, my lord, excludes the applicability of anticipatory bail. My lord, now kindly see the judgment compilation at page 33, my lord, of this compilation only, my lord. And your lordship may kindly come to paragraph 21 at page 55. This is the judgment of the Honorable Supreme Court, my lord, in citation 2019, 5 SEC, page 1, my lord. And it starts from page 33 and the relevant page is at page 55.
Yes.
Now, your lordship only see page 55, paragraph 22. And this is a case where the relating to regular bail, my lord, but still the certain principles will apply to anticipatory, my lord.
Yes.
Paragraph 22 at page 55.
Yes.
Paragraph, when it comes to offence, paragraph 22, your lordship, a middle of the page, my lord. of page 55, paragraph 22.
Yes,
Your Lordship got it? Yes. When it comes to the offences punishable under special enactment, such as the Act 1967 Act, something more is required to be kept in mind in view of the special provision contained in section 43D of the 1967 Act, issued by Act of 35 of 2008, with effect from 31st December 2008. Subsections 5, 6 are read as under, my lord. Now, I have already placed that provision, my lord, and then kindly see the paragraph 24, my lord, which is at page 59.
yes.
59. A priori, page 59,
Yes.
paragraph 24, my lord. A priori, the exercise to be undertaken by the court at this stage of giving reasons for grant or non-grant of bail is markedly different from discussing merits or demerits of the evidence. The elaborate examination or dissection of the evidence is not required to be done at this stage. The court is merely expected to record a finding on the basis of broad probabilities regarding the involvement of accused in the commission of the stated offence or otherwise. Broad probabilities, the requirement of law, as Honorable Supreme Court has laid down in paragraph 24, my lord, is the basis of broad probabilities regarding the involvement of accused in the commission of offence, my lord. And if your lordship will see this this whole discussion, it is based on paragraph 23, my lord, where this is there, but I'm not taking your lordship to that part of the matter, my lord. And then your lordship will see paragraph 27, which deals with the case diary aspect, and then 28, your lordship may kindly see page 60, 28E. The question. This is a case where regular bail was being argued, my lord. I am on the anticipatory bail. I am on the anticipatory bail issue. 28, your lordship will see 28E. The question is whether there are reasonable grounds for believing that the accusations made against the accused number 10, are prima facie true. That will have to be answered keeping in totality of materials, including the one presented along with the police report. Be it noted that prosecution is relying on several documents forming part of charge sheet filed against the respondent, allegedly showing his involvement in the commission statement. Reference has been made in these things, my lord. So, your lordship, this is the parameters which have been set by the Honorable Supreme Court. And then, my lord, the next judgment on I rely is of at page 90 of the Division Bench of Kerala High Court, my lord, which is very recent origin, my lord. It is of 21st July 2023, my lord. Now, facts are in paragraph 3 at page 90.
Yes.
Paragraph 3 at page 90, my lord. On 5th July 2020.
Yes.
On 5th July 2020. Paragraph 3, my lord. On
Yes, yes,
so
please,
30.244 kg of 24 karat gold valued at so and so was seized from import cargo addressed to the Consulate General of so and so, my lord. The gold was seized, my lord. It is seen that based on information, the proceeds of the smuggled gold could be used for financing tourism. Ministry of Home Affairs directed NIA to investigate. My lord, this is the fact. And then paragraph 12 at page 95. Because this is the fact where it is a case of smuggling of gold, my lord, and then NIA registered the case under UAP Act, my lord.
Yes.
Paragraph 12, my lord, paragraph 7 first, my lord. Also, your lordship kindly see 7, I'm sorry. 7, because 7 is dealing with the anticipatory bail aspect of the matter, my lord.
Yes.
When the arrested accused have been enlarged on bail, the appellant moved the special cause for anticipatory bail invoking 438 of the code. So this is the case where 438 was invoked, my lord. For that purpose only I showed paragraph 7. UAP case was registered in page para 3, my lord. Para 7 anticipatory bail was moved. And then, my lord, kindly see paragraph 95, sorry, page 95, paragraph 12, my lord.
Yes.
Now, after the matter was heard and orders and the reserve for orders, the learned Deputy Solicitor General of India has brought to the notice of this court the decision of the High Court in Bombay in Anand Teltumde versus State of Maharashtra. Anand Teltumde, my lord, which was being relied by my learned friend on the last date of hearing, in which application preferred by an accused in case of under a UAP Act for anticipatory bail has been dismissed as not maintainable, rejecting the identical argument put forward by learned counsel for the appellant that exclusion of application 438 of the code to the offences punishable under a UAP Act is not absolute. Learned Deputy General submitted that said decision has been affirmed by Apex Court in Tumbe versus State of Maharashtra 2021, 12 SEC, page 125. Lord. Now kindly see this judgment of Anand Tumbe, my lord, and your lordship will see the paragraph 16, my lord. 16 is at page 96.
Yes.
Because if 15, your lordship will find that the provision of UAP Act 43C and at page 96 itself, UAP Act is quoted, my lord. Paragraph page 96, then paragraph 16, my lord. As is evident from the extracted provision, subsection 4 of section 43D is the provision excluding the application of 438 of the code to any case involving the arrest of any person accused of having committed an offence punishable under UAP Act. Subsection 5 of 43D provides in addition that notwithstanding content, so we are not concerned with Milord 43D5 because that deals with the regular bail, Milord. So after discussing this, Milord, at next page 97, Milord, because
97.
Yes, 97, the preamble of UAP Act after 4 line is quoted, Milord. That this is pursuant to United Nations meeting, etc. Milord, paragraph 3, your lordship may take note that the amendment was carried out in line with the UN resolutions, Milord. And paragraph 17, Milord, thereafter, Milord.
Yes.
As evident from the preamble, the statute as stands now is one which has been amended in tune with the resolution adopted by Security Council of the United Nations under the Charter of United Nations requiring the member states to take measures to combat international terrorism and to take action against terrorist and terrorist organizations, to freeze the assets and economic resources, to prevent the entry or transit into the territory and prevent the direct or indirect supply, sale or transfer of arms entities. As noted, section 43D not only excludes the application of 438 of the code to the offence punishable under UAP Act, but also puts restriction on the person accused of offence punishable under 4 and 6 of UAP Act from being released on regular bail unless conditions in subsection 5 of 43D, namely so and so, are met, Milord. We are not concerned with that for Milord. Then page 98, Milord. After 5 line of the page 98, Milord.
Yes.
After 5, if the line starts, if the scheme of UAP Act is that no person accused of offence punishable under chapter 4 and 6 of you shall be released on bail unless two conditions referred in subsection 4 are satisfied, there cannot be any doubt that a statute does not complete grant of anticipatory bail to accused under the circumstances whatsoever. For if the provision is interpreted to hold that the statute does not bar absolutely application of section 438 of the code, in the absence of any restriction in the statute in the matter of grant, it would lead to anomalous and absurd position that anticipatory bail can be granted to persons accused of an offence punishable under UAP Act unconditionally, and restriction would apply only in matter of claiming irregular bail. Needless to say, that is exclusion of the application of section 438 of the code to any case involving any person accused of having committed an offence punishable under UAP Act is absolute. My lord, I am placing emphasis on this line and I am urging your lordship that this judgment has got persuasive value on this honorable court, and lordship may follow this judgment while deciding this matter. We take this view Also for the reason that right to seek anticipatory bail is not part of fundamental right guaranteed to the accused under Article 21 of the Constitution. Having regard to the present dimension and impact of international terrorism in civil society, UAP Act being being the statute intended for the prevention and terrorist activity, we are also the view the statute is framed, excluded application 438 to the code to the offence punishable under UAP consciously. Needless to say, an application is not maintainable in respect of offences punishable under UAP Act. Now, my lord, paragraph 18, because my friend has relied on that, as pointed out by the learned Deputy Solicitor General of India, identical view is taken by the High Court Bombay, also in Anand Teltumde, and the decision in the said case has been affirmed by Apex Body Anand Teltumde by State of Mind. We do not find any merit in the argument advanced by learned counsel the appellant based on the observation made by Apex Court in para 2 of the judgment in the said case. For the Apex Court in terms of said judgment affirmed the view taken by Bombay High Court that application for anticipatory bail preferred by the accused involved in the case is not maintainable. There is also no merit in the argument advanced by the learned counsel for the appellant based on decision in so and so, my lord. And then your lordship kindly see paragraph 24 straight away at page 104, my lord. Because SC/ST Act provisions were being invoked, and in that context, the Honorable Division Bench of Kerala High Court in paragraph 24 held at page 104 at the foot of the page, it is thus evident.
Is this relevant? Is this irrelevant?
Page 10, only for the purpose of showing that excluded. 438 is excluded. That's all, my lord. Nothing more, my lord. I am required.
Your point has been made and taken note of.
Yes, yes, lordship. Now, your lordship, the next judgment, if your lordship will see, Anand Teltumbe 108, my lord. That is the judgment which has been referred to and relied upon by the Kerala High Court, my lord, of Maharashtra, of Bombay High Court, which is at page 108, my lord.
But this has come up before the Apex Court, isn't it?
Yes, in Bombay High Court judgment, the Bombay High Court held, my lord, that in view of bar under section 43D, anticipatory bail provision will not apply, and that was affirmed by the Honorable Supreme Court in page 139. If your lordship straight away wants to see that order, which is at page 139. It's a one page judgment and order of the Honorable Supreme Court affirming the judgment of Bombay High Court in Anand Teltumbe.
Yes.
Paragraph 1, we have not mentioned the facts in detail as requested by learned counsel for the petitioner. However, we are satisfied that in view of the provision contained in 43D4 of the Act 1967, which excludes the operation of 438 CRPC, that no case is made out to exercise power under 438 section is extracted. 2, we are of the cannot be said no prima facie case is made out. Petition cannot be said to be maintainable in view of 43D4 of Unlawful Activities Act. Now, my lord, this aspect, your lordship, kindly see now allegations against the accused person, and straight away I take your lordship to the FIR, my lord. At page 33, my lord.
Page 33.
Of the petition.
Page Annexure 4.
Of the petition, bail petition.
Bail petition.
Yes.
The lordship will see page 33, Annexure 4. With due respect, it is to be informed that yesterday on 24th July, a mob of approximately 500 anti-social elements assembled outside the mini secretariat, so-and-so, when talks between Honorable Chief Minister of Meghalaya and the protesting NGOs were going on. At around 4 p.m., they started shouting slogans and inciting violence among the mob. it has been learned that aggressive conduct of mobs was out criminal conspiracy done by below mentioned member. And then you also will see at the next page, my lord, after the names are mentioned, my lord, page 34, middle of after the table, my lord, page 34 after the table, after the name of the accused are mentioned here, my lord.
Yes.
Later at around 6:45 p.m., the mob started pelting stone at the government servants on duty due to which at least 18 Meghalaya police at CRP were mentioned below sustained serious injuries of their person. So their names are mentioned below. Now thereafter, my lord, next after table, my lord, further at least 21 government private vehicles got damaged, out of which 2 vehicles were completely burned and 2 vehicles were partially burned. The damaged vehicle includes the carcade of Honorable Chief Ministers, so and so, and other government. Then thereafter, the details of vehicles are given below. Then at page 35, kindly see the number of vehicles, number of persons injured. Apart from this, mob damaged many window panes and door of mini secretariat building by throwing big stones, bricks, and batters. More than 100 chairs used during the peaceful protest over last 2 weeks, and the temporary pandal was set to fire. Credible source information suggests that it was an attempt to murder Honorable Chief Minister, MLA, Deputy Commissioner, SP, Executive Minister, and other government servants for duty. This is a clear case of waging war against the state with pre-planned conspiracy by the above mentioned miscreants, and therefore it is requested to register cognizable claims and take steps against them as per law. So the section which I have read out, section 15, my lord, and 13(1)(a), they are clearly made out. Facts of the case, my lord, and your lordship would notice that in the bail application, 2 things which I want to place, my lord, what they say in the bail application. If your lordship would see, in the prayer is that they admit in the synopsis itself. They say that they were present at the site, and second fact is violence was incited. That is also not disputed by them. 2 facts, my lordship, need to notice. One, their presence is admitted, my lord, and violence, and they are saying that no, they were not part of the mob, and they were not part of the conspiracy. That is the defense they are trying to set up, my lord. But their presence in this assembly and their role in this assembly is not at all denied by them. Kindly, in the light of these facts, my lord, the bar which is there in law, is quite categorical and unequivocal that 438 will not apply. Now, your lordship, kindly see the case diary, and then I will take your lordship straight away to the relevant pages of case diary. Because this issue, whether the bar will apply or not apply, this issue was also raised before learned district and session judge, because regular bail was being moved. Okay. They have moved before your lordship and suppressing certain very important facts. In one of the case, my lord, in Balkarin, the person, next item, the person was accused of offence of dacoity, etc., and he moved anticipatory bail before your lordship, and your lordship rejected the bail application, and what he has said that there is no criminal antecedent pending against him. That vital fact is also suppressed, my lord, in item 16, that I will place separately. But first, I would like to know I would like to place the case. Kindly see page 412. Page 412 of the case diary.
Yes.
This is the case, and the matter came, and then page 413, my lord.
Yes.
After 4 paragraphs, my lord, of the order of learned, page 41, order of the learned district and session judge, my lord. This is the order dated 28th July, my lord. Your lordship got it, page 28th July of learned district and session judge, my lord.
Yes.
And on next page 41.
That is 412.
Yes, my lord. And kindly come to page 413, my lord.
Yes.
at middle of the page, my lord.
Yes.
And then the section is the learned district and session judge record. Though the offence registered under the accused person is very serious and grave, it is not under how Section 13 Act is attracted in the case. Then Section 2O is quoted, my lord. And on next page, your lordship will find at page 414. 414.
Yes. Yes.
Let the IO submit report with regard to offence under UAP Act by 1st August 23, my lord. Lordship got the part of the order at page 414.
Yes. Yes.
Yes. Then your lordship kindly see page 314. Because the pages are upside down, because that page should have come in numbering. I saw some mistake, my lord.
314.
314, my lord. Now, this is 1st August. IO has, second paragraph, my lord. IO has submitted clarification dated 1st August 23, justifying the inclusion of Section 13 of UAP Act in this case, stating that an attack on Chief Minister of the state not only threatens the safety and security of individual leader, but also strikes at the very heart of the state's sovereignty, integrity, and democratic principle. That attack on Chief Minister has far-reaching consequences in law and order, public order, and overall functioning of state machinery. That the Chief and MLA are constitutional position representing the state, hence an attack on them is an attack on the state and its sovereignty. Since the case is at this stage of the court would not like to interfere with the provisions of law incorporated by investigating agency. So this order, my lord, also of learned session judge,
Yes.
says that UAP Act is applicable, my lord, and at this stage it could not have been interfered, my lord, because so therefore the rule is very much clear, my lord. Now your lordship kindly see page 516, my lord. Annexus C5, my lord.
Yes.
This is the Annexus C5, page 51.
This was in course of investigation.
Yeah, this is the course of investigation, my lord. 10th August. This is the 10th August, and invocation and the section 15 and 16 has also been invoked, my lord. Earlier in the FIR, 13(1)A was there. With due respect and humble submission, I have the honor to pray your honorable court to kindly add section 15 and 16B of UAP Act with the above PS case number. And after recording the everything, my lord, what we have been, and on next page. Moreover, an attack on Chief Minister, far-reaching consequences in law order, public order, overall functioning of the state, it can lead to violence, disrupt and administration, hinder the implementation of and aimed at the welfare, progress of state resident, Chief Minister of MLA, our constitutional position, etc. My lord, and 15. The point I was trying to make, my lord, that if in the democratic society, in peaceful society, there is no place of terrorist activities, there is no place to raise slogan, my lord, and if that is allowed, that is permitted, my lord, then the whole democratic fabric, whole sovereignty, whole security of the state will go away. Your lordship has seen the disastrous consequences which have taken place in the state of Manipur when the state was handling, when we could not curb these kind of tendencies, my lord. So in these matters, there are enough material to show, and their role, my lord, at page 280, your lordship will see one of the witnesses have named them or is 280 of the charge sheet, my lord. Now kindly see, my lord, the Bal Kiran CH item 16, my lord, because that is the item 16, my lord.
You're referring to?
The item 16, Bal Karin CH Marak case.
Bail application 16.
No, that is okay. But you're referring
In
to
that case, my lord, this person has suppressed the fact that he is accused.
Page number.
Your lordship will see the page number where he makes the submission, my lord, at page 10.
Yes.
Paragraph 3, my lord. The petitioner is a law-abiding citizen having no criminal antecedent whatsoever. He is having deep roots in the society and there is no complaint or adversity against the petitioner from any corners of till date, my lord. This is his false averment on oath before your lordship. He can be prosecuted for making false averment. Kindly see the order passed by your lordship on 10th March 2022. My friend will pass 10th March order. In the case of Bal Karinol only, Bal Karinol. This is the bail, anticipatory bail application moved by this person, my lord. And the petitioner has approached this court.
Anyway,
With
was he ever convicted in this case?
he sought anticipate. No, I'm only saying what he says that he is not. What is his averment in para 3? He says that he is not facing any criminal case. There is no criminal case he is facing. And criminal case facing conviction will come later.
You're referring to his criminal antecedent.
Yes, and why? And I'm referring to criminal incident for reason is, my lord, he made a false affidavit in the bail application.
Being involved in a criminal case doesn't mean that you are a criminal.
No, your lordship, I'm not saying that. I'm not saying. At the moment, I'm not suggesting that, my lord. What I'm saying in paragraph 3, he is saying, my lord,
that is irrelevant.
he has no complaints or adversity against any corners of society, and he says no criminal antecedent, my lord. Can he say person who is facing 2 criminal cases, and your lordship has rejected bail in 2 cases? Can he say that he has no criminal antecedent, my lord?
That is
I put a question to myself: is he not making a false statement before your lordship? Would your lordship not take serious note of his false statement which he has made in paragraph 3? And this is if the pleading, if he's saying I have no criminal incident and I'm placing your lordship where he has moved and there are 2 criminal cases pending against him. This is a outright false statement, my lord. Whether person with approaching anticipatory bail can say all these things, my lord. And why is he approaching before your lordship? I have placed 4 judgments on this, your lordship. I will briefly. Why is he approaching this court? Your lordship has power to grant bail under 438 when in other regular matters, not. But the session judge he is avoiding because learned session judge is aware of the ground realities, and he has not given any reason as to why he is. Because your lordship has got discretion, and that discretion has to be exercised in judicious manner. That is what, my lord, in my compilation 4 judgments are there, my lord, on this issue only.
Fine.
And that your lordship will see at page 141.
I think you have made your point, Mr.
Yeah, and then section is there, and 430D, 43D, 4 bar is there, my lord. It's an absolute bar.
That is noted.
Please, Lordship. Lordship, before I go to the judgments, I would like to, my lord, brief your lordships the facts. My lord, what happened, my lord, is that on 5th of July 2023, lordship, a permission was sought.
See, Mr. Deb,
Lordship.
got the whole proceeding short. Whatever the case may be, FIR has been lodged, you have been named.
I have not been named, my
You
lord.
may not have been named, but you are part of the investigation. So rather, you have been investigated into,
Lordship.
for which in anticipation or in apprehension of being arrested, you have proposed this court.
Lordship.
But the provisions are very clear.
If I may, subject to your lordship's consideration, my lord. Lordship, what I am trying to submit, my lord, is that these petitioners, my lord, in all the items, they are the leaders of the NGOs.
Only thing is, we will not go into facts.
I'm just trying to, my lord.
Just go into factual,
Yes.
go on the legal aspect.
Lordship, yes.
If you can convince this court that section 43D4 can be overcome,
Yes, my lord.
then
In my humble submission, my lord, if lordship again comes to, my lord, the Supreme Court judgment, lordship, at page 139 of the compilation.
139.
139 of the compilation.
Yes.
If Lordship comes to page 140, Lordship, page paragraph 2. Lord, I am stressing my argument on the first line of paragraph 2, Lordship. We are of the opinion that it cannot be said that no prima facie case is made out. What follows, my lord, is that the petitions cannot be said to be maintainable in view of so and so. So what I'm trying to submit, my lord, is that these kind of bars are there under the TADA Act, under the SC/ST Act, even under the NDPS Act. Two issues, my lord. The first is that, in essence, my lord, he has to convince the court that there is no prima facie case apparently on the record. If that is made out, my lord, if the court is convinced that even in case of a regular bail, a person who has already been arrested, accused, already arrested, coming for regular bail, does not have, from the record, there is no prima facie material suggesting his involvement in the offence is made out, then he is entitled to regular bail. That same principle, my lord, would apply in a case for anticipatory bail where no prima facie case is made out, lordship. So my lordship will see a situation, my lord, that these are very draconian laws. Once a person is charged under these laws, it's very difficult for the person to prove his innocence, lordship, because the presumption is always there. Now, my lord, the incident which happened in Tura is a very unfortunate incident. There's no denying it. The Honorable Chief Minister was there, other dignitaries were there, and there was a violence. There is no denying it. It is a very serious situation, my lord. But whether my lordship has seen that in the original FIR which was filed immediately after the incident, 46 people were named, my lord, along with their affiliations. I was not named in those 46 people. On the next day, my lord, the IO submitted his forwarding report and arrested another 18 to 20 persons. I was also not amongst those 18 to 20 persons. On what basis they have been arrested, my lord, lordship will have from the forwarding report, is that two other leaders who were not originally named in the FIR as accused or conspirators had allegedly enticed them by giving speeches and sloganism, my lord. I am not amongst those two people also. It is only now, and lordship will kindly appreciate that we have moved the bail application on 8th of August. On 10th of August, my lord, they have added section 15 and 16, which is terrorism activity, my lord. To brand someone or to allege that someone is a part of a terrorist organization committing a terrorist activity, my lord, has grave consequences. It cannot be just mechanically invoked against any person, my lord. And here, lordship will kindly see, the fact is, my lord, what they are also not denying and we are also saying, my lord, is that at the time of the incident, I was inside in the meeting along with the Chief Minister and others. In such a situation, my lord, can it be said that I have indulged in any terrorist activity? There may or may not have been a violence outside. Someone may have done it, someone may not have done it. But can I be mechanically charged with the UAPA and all these acts only for the sake of, my lord, to create this embargo? Because lordship will kindly see, this incident was widely reported all over the news. At the time the incident occurred, it was widely reported even by the Honorable Chief Minister's office that the NGOs who were agitating since the last 14 days, even prior to the incident, were agitating based on a permission. It was not unlawful association. Permission was sought from the DC. Permission was granted. Agitation was going on, my lord, for 14 days. On the 14th day at night, this incident occurred, and it was widely reported that the persons behind this entire incident, my lord, were people not belonging to the NGOs who were protesting since the last 14 days. They were people from, allegations were made on political accusations were made, other accusations were made, and in fact even the FIR shows, my lord, lordship, I have never seen an FIR where the political party of a person or whether he is a former GNLA member is mentioned. And interestingly, some persons have also been named in the FIR from the ruling party, but they are politicians, but that's a different aspect. What I'm trying to only submit, my lord, is that by mechanically invoking section 13 and now after filing of the bail, section 15 and 16 only to make it even more difficult for me, my lord. Whether in such a situation, my lord, there will be an absolute bar just because a mechanical section has been mechanically invoked. Lordship, tomorrow I may throw a stone at someone and an FIR is lodged that I am trying to, my lord, cause public unrest and it is affecting the integrity and sovereignty of that will not, my lord, stand. And lordship will kindly see that if I was arrested and I would come under 439 for regular bail, I would have to satisfy two conditions. One, my lord, of course, is that the public prosecutor has to be heard and reasons have to be recorded in writing as to why I am being. And the second thing is, my lord, the court has to be convinced that there is no prima facie case made out. I cannot bring out any new defense. It has to be born from the record itself, my lord. A similar yardstick, my lord, would apply in a case where I am saying, my lord, that I was not present. In fact, I was present along with the people who were injured. And that is also not denied. Nowhere it has been denied, my lord, that at the time of the incident, I was inside the building. I was inside the building till 1 a.m. in the night. I was escorted by the police themselves to my residence, lordship. After my lord, the heat subdued a little bit. In such a situation, my lord, and considering the Supreme Court, my lord, the other High Court judgments, of course, I'm not going to that. But here, my lord, the one line which really helps me, my lord, is that there, in this case, evidently there was a prima facie case. What I am saying, my lord, is that there is no prima facie case whatsoever against me, not only under the UAPA Act, under any of the sections which have been invoked, because of the fact that, my lord, neither had I unlawfully assembled. Assembly was on basis of a permission. I was invited to the meeting by the concerned authorities. I was present inside the meeting when the incident happened. I was with the concerned authorities and the Honorable Chief Minister till the time, my lord, everyone was escorted out of the building by the police themselves. They dropped me to my house. Now, my lord, after 2 weeks, it is being if I may humbly submit, what is actually happening, my lord, is that the persons who have been named in the FIR had moved anticipatory bail applications and regular bail applications before the learned court at Tura. In the learned court at Tura, my lord, those bail applications were rejected. But what also flowed from those bail applications, my lord, they have put my name, saying that it is not us, it is not a political there was no political motive behind it. It was the NGO leaders who had instigated the crowd. And in fact, my lord, yesterday also I had seen on newspaper that one of the persons who was arrested belonging to a certain political party, her husband has also seemingly lodged an FIR against of me, saying that I am these NGO leaders are the people who are the actual instigators and conspirators behind this entire incident. But that is, of course, my lord, we don't know whether the FIR is registered, what is the stage. But lordship will kindly see, right from the very beginning, there was no allegation that the NGO leaders who were conducting the hunger strike since the last 14 days, who were invited by the Honorable Chief Minister to hold talks so as to resolve the disputes, positive deliberations were going on, my lord. Why would I be being the leader of an NGO where I am inside having talks with the hope that, my lord, my demands will be addressed? Why should I entice, my lord, any violence? And the fact remains, my lord, that even the FIR would show that none of the people who have been named in the FIR as alleged conspirators belong to the NGO. They are all BJP, TMC, this and that, my lord. Now to say suddenly that NGOs are the actual offenders and to shift, my lord, what is happening is that this is becoming a political blame game, and in the middle of all that we are being sandwiched by these draconian provisions of UAPA Act. So, my lord, on the facts, lordship, of course I don't want to say anything in defense or say anything, but lordship has seen that, my lord, what I followed from learned senior submission is that allegedly one witness has taken one name of one of the petitioners. The other petitioners are still unnamed. But yet, my lord, police are looking for them. They are being implicated in the case without having any role to play, my lord. In such a situation, whether lordship will see 43D and the purpose of 43D, my lord, is to prevent terrorist activities. And so that those people who are from unlawful organizations or from these so-called terrorist organizations, those people, my lord, are not enlarged without any strict conditions, because that would naturally affect the security and integrity of the country and the state also, my lord. But here, lordship, there was the thing is, my lord, that we, being the NGO leaders, cannot be said that we were holding an unlawful association, because permission was given. It was the 14th day. If it was unlawful, if it was the case that this protest that is going on is amounting to an unlawful activity, that I am sloganeering or I am causing disruption to the public authorities, 14 days, my lord, it was going on. And protests are held every now and then in the state, my lord, and those are not branded as terrorist activities or unlawful associations. Unfortunately, my lord, an incident happened, and that incident has to be, my lord, highly condemnable, has to be taken seriously. But what role do I have to play in that, my lord? By mechanically invoking UAPA Act and other provisions, my right to life itself is, my lord, getting hampered. So lordship has to take a holistic view, my lord. I humbly submit that the 43D bar would not be absolute in a case where no prima facie case itself is made out against the accused person from the case record itself. That is my submission.
My lord, if I can reply to my learned friend, if my lord has a copy of the first bail application, Lebanon CH Mara. My lord, may kindly come to page number 31. My lord, this is the permission, my lord,
Yes.
which was given on 10th of July 2023. The permission, my lord, I will just read it. As per the views and comments submitted by the Superintendent of Police, West Garo Hills, Tura, by letter number so and so, permission is hereby granted to the General Secretary and President, Krima Council, Achik, West Garo Hills, Tura, to hold peaceful democratic demonstration for demand of implementation of reservation roster with backlog policy and implementation of winter capital in front of Mini Secretariat Office Gate, Dakapgre, on 11/7/2023 in strict compliance and observations with the following terms and conditions. Permission was granted, my lord, to hold a peaceful democratic demonstration
That is routine.
only for one day, my lord. That is on
That was extended, my lord.
that is on 11/7/2023. Whereas, my lord, the incident, my lord, that has taken place on 24/7/2023, and therefore the petitioners claim that the association was lawful. It is totally illegal, my lord. That is, the entire association was illegal, my lord. That is without any permission, my lord, and permission was granted only for a day, and that also, my lord, that is a peaceful democratic demonstration. Here, my lord, 21 vehicles have been totally damaged, 2 vehicles have been burned down, 18 police personnel, then CRPF and Home Guard personnel, my lord, they were seriously injured. And this is not a peaceful demonstration. And moreover, my lord, as far as section 43D is concerned, my lord, if my lord will come to section section 48 of the UAPA Act, my lord. Now it says, my lord, effects of acts and rules, etc., inconsistent with other enactment. The provision of this act or any rule or order made thereunder shall have effect notwithstanding anything inconsistent therewith contained in any enactment other than this act or any instrument having effect by virtue of any enactment other than this act.
In any special act or special provision.
Right. Now, my only contention is there, my lord. As far as section 43D in UAPA Act, my lord, this is a code of its own because it has the overriding effect. This is a code of its own in respect of bail because it has the overriding effect in other statutes as far as CRPC is concerned. This overrides even CRPC because if my lord will see section 43D,
There is no dispute with that, my lord.
my lord, section 43D, my lord, subsection 2, it even modifies and amends section 167 of the CRPC, my lord, as regard to the days of, as regard to the days, under for how many days a person can be kept in detention, my lord. Now, if my lord will come to section 15, my lord, of the same act, section 15, subsection 1, clause B. It says, overrose by means of criminal force or show of criminal force or attempt to do so, or causes death of any public functionary or attempts to cause death of any public functionary. Here this serious attempt.
Mr. Sincon, as far as the purpose and ambit of the act is concerned, the statutes would speak for themselves.
Right. And
there is no quarrel there.
And as far as, my lord, as far as the petitioner, they have approached this honorable court directly without going to the session court. My lord has already held in one of the case, my lord.
Right. And as far as, my lord, as far as the petitioner, they have approached this honorable court directly without going to the session court. My lord has already held in one of the case, my lord.
My lord, if my lord will come to page number 6 of the judgment.
Yes.
Here we will read from paragraph 23, my lord. Before answering this question, the twin objections raised by the learned AAZ may be taken up first, as the issue of maintainability is involved. The first objection is that since the accused had approached the session court under section 439 CRPC, therefore he cannot approach the High Court under the same provision except by way of appeal. Paragraph 24. In case of Sri Kwamta Gwara Brahma versus State of Assam, the Honorable Guwahati High Court Vice Judgment and Order dated 10/4/2015 passed in bail application number 3024/2014 dealing with the issue of law as to whether it is essential that a person accused before approaching the High Court for grant of anticipatory bail under section 438 of CRPC and grant of bail under section 439 of the CRPC should exhaust his remedies before the session court and then file application before the High Court, has elaborately dwelled upon the subject and for the limited purpose relevant to the issue in the question held as, after carefully analyzing the ratio laid down in the above decisions, the salient aspect that emerges is to the effect that insofar as the provision of section 439 are concerned, no option to choose the forum is given to the person accused, unlike under section 438. When the inferior court and the superior court are invested with concurrent jurisdiction, normally a person accused has to exhaust his remedy before the inferior court. If the person accused is aggrieved by the order of the inferior court, then he can approach the High Court, in which event the High Court will have the benefit of considering the reasons and opinion given by the inferior court. In the event of rejection of bail application by the session court, the person accused can still move the High Court for grant of anticipatory bail under section 438 of the CRPC or bail under section 439 of the CRPC, as the case may be. In view of the reasons and discussions made above, it is held that normally a person accused should exhaust his remedy under section 438 or 439 of the CRPC before the session judge making an application before the High Court under section 438 or 439 of the CRPC. Now, in this case, my lord has observed that they should first exhaust their remedy in the session court, my lord. Here, my lord, just because some of the bail applications has been rejected, they have directly come.
This is not a hard and fast rule.
The option is given to me to choose which forum. I have not. In fact, my lord, I would only take lordship to one page for my page 41 of the petition, my lord.
Yes.
In fact, page 40, my lord, is the first page. This is a news report, my lord, which was published on July 24th, which is the date of the incident, 11:22 p.m. Lordship will kindly see it just above the picture, my lord. So immediately after the incident, lordship. Lordship may kindly have the next page at page 41. In court, my lord, Meghalaya CM Sri so-and-so has was having discussions with agitating organizations based in Garhwils who are on hunger strike for a winter capital in Tura. CMO PR, this is the Chief Minister's Office Public Relations Officer, PRO, said. Meanwhile, a crowd other than agitating groups gathered at the CMO in Tura and started pelting stones. Police fired gas shells and dispersed the crowd, so and so. My lord, even in the official statement made by the Chief Minister's Office, a crowd other than agitating groups. It was not, my lord, and Lordship will kindly see 2 paragraphs later also. Sources say that stone pelters were outsiders who came to Tura with the intention of creating trouble. They are believed to have had their own vested interests and they are not affiliated with any local group or organization. And this, my lord, is what has been reported across all the newspapers, that it was some people with vested interest who came and it was not the protesting NGOs. Now, as far as the permission was concerned, my lord, original permission was given on 11th. Thereafter, my lord, the Deputy Commissioner, we started the protest on 11th itself. I have made a statement also in the petition, my lord, that a verbal assurance was, the Deputy Commissioner himself came to the venue, allowed us to continue the protest, and thereafter, my lord, the government said, my lord, that they will come and visit. That situation would have never come if it was the case, my lord, that from 12th onwards the assembly itself is unlawful. Assembly was never unlawful, my lord. I was inside.
Yeah, that is your version.
My lord. And moreover, my lord,
What does the IO says here? Where is this?
Where is my role, my lord?
even
in
in
the case?
275, my lord, if my lord will come to page number 275 of the CD, here the accused person's name have been reflected. You are not entitled for this.
275. Well, that's what he has said. Somebody has accused.
They are the people who have.
Somebody has inferred that he was.
Yes, right.
And all those things.
And moreover, my learned friend has referred to newspaper reporting. Through a newspaper reporting, we cannot come into any conclusion, my lord. This is part of investigation.
That is why, see,
Yes.
this court has insisted on you. See, after all has been said and done, now where is the exact
Role.
Investigation report that this is the role played by the petitioner?
Now, my lord, as far as
Except for this statement, just 275.
as far as that point is concerned, my lord, petitioners, my lord, they have admitted in their petition they are part of the association.
No, where is the noting of the IO?
My lord, in one of the
Because when you come to the issue of
only regarding
a prima facie case,
right.
it has to be borne by the.
In one of the forwarding report, my lord, to the court, the IO has stated that some of the witnesses, they have referred name, some of the accused, they have referred name of the other people which were not disclosed here, my lord, because it cannot be disclosed also. It's unless and until they are arrested, my lord. Unless and until, my lord, they are arrested.
May I, with my friends here, my lord, in the case here is that admittedly, if your lordship see the bail application itself, what they say that he was the president of this organization. He was present at the site when violence has taken place. He says that he did not incite the violence. His defense is he did not incite the violence. It is his defense, my lord. Now, for establishing prima facie case, what state is required to show that violence has taken place? He was part of unlawful mob, my lord, and his names have been taken by the other accused persons. And only after interrogation we will get more material. Who are all other conspirators, my lord? And because he is absconding, others have been arrested. He is absconding. He is absconding. He has not surrendered, my lord. He has not even gone to session court, my lord. Now, therefore, your lordship, what do I require more to prove? On face of his admission, my lord, he has also argued that his name has been named. The other witnesses have named him, my lord, and he himself says that I was there. And his defense is I was part of peaceful. And your lordship, kindly in FIR, on bare perusal of FIR, is it peaceful when the under section 15B, 15(1)B, when there is attack on the head of the state, my lord?
See,
and he is part of that
there is
unlawful
see, Mr. Kumar, there is no dispute as to what actually had happened. That is very
So
it's
then,
plain and
if
clear.
I take it from there, so now
The only thing now is
I
to
take
be the only thing now that has to be proved is what is the role played by
see that will
all
come
the
in
players
not
involved.
all these issues will come in investigation
It has
in the
to.
course of investigation which when he is arrested and he is interrogated, Milord.
Okay.
That is what, and that is the bar which is there in 43D, Milord. Because if he says his alibi is not, he was not there on, he could have said I was there in Shillong, I was not at the site. Then the responsibility onus would have been on the prosecution. So no, you were at the site, and you who all instigated him, who he was instigating the other mob members also, Milord. And his defense is that newspaper report says that he was part of peaceful protest, Milord. If that is all he is arguing, Milord, then there will be no bar under 43D, Milord. There will be no bar, and
Our first
15(1)B is very clear.
First question that needs to be decided is whether the application itself is maintainable. After that, my lord, we can go to other aspect.
I'll go through the CD.
Yes, ma'am.
Yes.
About the parties, I'll pass this orders. Let me read.
Otherwise, we are, my lord, if this honorable court is pleased to grant anticipatory bail, we are, my lord, needless to say, fully cooperating, fully ready to stringent conditions.
That would be the stock submission in any case, in all these cases of this kind.
Obliged.
For abundant caution, I'm just being
Yes.
obliged, lordship.
Right. Very honorable.
Thank you.
Daily cost list item number 1.
Please, Your Lordship. Your Lordship, in this matter,
Some difficulties today. If it is taken up any other day.
See, this matter is
Part heard, Lordship.
part heard. Now I don't know what part has been heard.
That is why, Lordship, we want to make some oral submission, Lordship. It is
In fact, written arguments are filed, my lord.
2021, Lordship.
Oh,
Written arguments are also filed.
Heard 2021. Subsequently, first I filed my written submission, then later on my friends filed their written submissions. Here only I have framed 3 issues, Lordship. Now he is saying that Meghalaya Education Act is not applicable in aided schools. That one of the issue. And another issue, Lordship. Now since my friend is asking for accommodation,
you have filed your written argument also.
Yes, my lord.
Then
We filed it,
you just to refresh the court.
my lord.
So do it.
That's, otherwise, it can come up next week, my lord. I have no issues.
On prey made by the parties. This is matter to 1 week. But be sure, you see, it's an old matter. 2016.
1 week or 2 weeks?
What?
1 week.
1 week. It's school matter. Appointment or
This is reduction of rank, Lordship, after 15 years.
that the headmistress thing.
Yes, Lordship.
Okay.
15 years.
All right, my lord.
Item number 3.
Lordship, this matter may be taken up after a week. Lordship, this matter was previously handled by Mr. B. Shaji and Justice B. Shaji, now additional judge. Lordship, this matter is being re-endorsed to different council. Lordship, this matter may be taken up after 1 week.
Lordship, I think I'll request 2 weeks because the headman.
With respect to respondent 7, Lordship, we have taken steps, Lordship. Then we have filed a service also, affidavit of service, Lordship.
Oh yeah. Affidavit of service has been filed.
Yes, Lordship.
Lordship, if I may, Lordship, just off the record, I was appearing for respondent number 7, Lordship, initially. Then thereafter, I had to withdraw myself because of my appointment. Now, they've just called me just last week, Lordship, just asking me to inform this Honourable Court that they're yet to have a meeting to appoint a new council, Lordship. They have received notice from this Honourable Court, Lordship. So just to apprise the court of the present situation, Lordship.
You have filed affidavit of service?
Yes, Lordship.
We'll record them. Where a counsel for the petitioner has submitted that the notice issued upon the respondent number 7 has been affected, and in this regard, an affidavit of service has been filed. However, the respondent 7 is not present today. The respondent 7 is requested to be present on the next date fix. As prayed for by the parties, this is matter to 2 weeks.
That's right.
Item number 4.
Chief, that I am appearing on behalf of A. Borua, Lordship. He has some personal difficulties, Lordship. He could not come today. He just requested me to mention the matter, Lordship. For 3 weeks, Lordship.
On premier by petitioner, on ground of personal difficulty, matter is adjourned. Recess after 2 weeks.
Item number 7.
May it please your Lordship. Lordship, this is a civil revision petition where we've challenged the learned appellate court's, the first appellate court's order. The main contention is regarding 2 sale deeds existing parallelly. But Lordship, however, I'm praying for some accommodation in this matter because the learned assisting counsel is unavailable today, Lordship. He's having some personal difficulty attending court. I'm praying if this matter may be listed next week.
Yes.
Let the matter come up next week, Your Lordship.
On premier by the parties, this is matter after 2 weeks.
Highly obliged, Lordship.
Obliged.
That will give you more time to prepare.
Lordship.
Obliged.
Item number 8.
Lordship, in this matter as well, I'm seeking some accommodation.
Lordship, actually, when a mention is being made, especially in a hearing matter, it ought to be mentioned beforehand.
Exactly.
And courtesy also demands that when you are taking a adjournment, you should inform the other side. I mean, this is not only for this case, but I'm speaking about generally.
Today, especially, I've noticed that.
Lordship, if I may just humbly submit, senior counsel was supposed to come. He was on his way, but due to some personal difficulty, had to return. We were supposed to take up this matter, Lordship.
Please don't take the excuse of traffic jam again.
No, Lordship, not traffic.
What Mr. Dingdor said is correct. See,
Lordship, I agree.
time and again, when a matter has been, is being mentioned, the court would always insist that the other side be informed.
Lordship.
Otherwise, the matter is taken up. Mr. Dingdor was here this morning. You could have.
Lordship, I did inform his junior counsel, Lordship.
So how long?
Lordship, next week.
On premier by the UFO.
I'm for the respondent, Lordship.
Premier by the respondent on grounds of personal difficulty of the learned conducting counsel. Matter is adjourned. This is after 1 week.
Highly obliged, Lordship.
Item number 9.
Please, Your Lordship. Your Lordship, in this case, the short point for consideration before Your Lordship is in view of the judgment rendered by this court in the Sheila case, whether the Limitation Act is applicable even for the courts in the District Council. That is the short point. My Lord, in 2011, the respondents had instituted an ejectment suit. Now, on 7/2/2013, the suit was dismissed for non-prosecution. Then, after 2 years, these dates are important.
Yes.
Suit was instituted
Suit was instituted
on 2011.
Yes.
It was dismissed for default on 7/2/2013.
Seven two.
7/2/2013.
Yes.
And Your Lordship, on 15/2/2015, that is after more than 2 years, on 15/2/2015,
Yes.
they filed an application for revival of the suit, setting aside the order.
Yes.
Now, unfortunately, my lord, this the hearing took place only on 15/10/2018.
Yes.
And my lord, although we have raised the question of limitation, because the lordship is aware that an application for setting aside a dismissal order is within 30 days. So we raised the issue of limitation. Otherwise also, because they took the stand that limitation is not applicable. Otherwise also, 2 years is a long time. Even if the Limitation Act is not applicable, you have to show cogent grounds as to what prevented you from filing the application within time. But brushing aside our submissions, the trial court, what it did, while allowing the petition, in fact, put the blame on us, on the appellant, that you are the one who has dragged on this case. I will just read the operative portion of the trial court's order. That's at page 10 of the appeal petition, annexure 2. Relevant page at 11.
Yes.
Page 11. Now the case is posted today for hearing on the restoration. Both parties are present and filed hajiras. The learned counsel for the plaintiff had filed an application dated 15/5/15 for restoration of the suit. The defendant number 1 also filed show cause number 651 of 17. The instant suit was dismissed for default on 7/2/2013. The plaintiff then filed an application for restoration of the suit. The learned counsel for the plaintiff submitted that the suit has already proceeded and the question of restoration will not arise. The defendant number 1 had all along taken part in the proceedings, and as such the instant suit is restored back to file. Now what happened, my lord? It would appear from what the trial court has said, although the suit had been dismissed, it continued. How it happened, my lord, I don't know. It continued, despite that it has been dismissed, maybe through inadvertence or whatever. The court did not realize this fact and proceeded ahead with the suit without looking into the aspect of the matter that the suit has since been dismissed. Now,
in that case, then the issue of dismissal has become redundant. Then.
What?
I said the issue of dismissal has become redundant.
But the order was never set aside. It was never set aside. When the court realized, and when the counsel for the parties realized that there is a dismissal order, then we were allowed to file a show cause, and the court fixed it for hearing. It would be a different matter if the court had said, as your lordship has observed, that it has become redundant in view of the fact that the suit has proceeded. But when it was brought to the notice of the court, the order was brought to the notice of the court, then the court said, yes, we have to hear this petition first. Okay. Learned counsel for the defendant number 1, on the other hand, submitted that she had filed a show cause. She submitted that the instant application is barred by law of limitation. Furthermore, the statement made in para 2 is denied, as the written statement was not filed due to the failure of the plaintiff to take steps. It is prayed that the application be dismissed. I have heard the learned counsels for both the parties. I have perused the instant application along with the show cause. The instant suit was dismissed for default on 7/2/2013. The plaintiff then filed an application for restoration on 15/5/15. Now, my lord, notices were issued to the defendants, but it was only the defendant number 1 and 8 who entered appearance, and white order dated 3/8/16, the defendant number 1 expressed that she does not want to contest the suit. The notices to the other defendants were also issued, but defendants number 2 to 14 refused to accept notice since the suit had proceeded only against defendant number 1, white order dated 25/10/16. Therefore, it is clearly seen that the defendant number 1 had been appearing and may be well aware of the restoration application dated 15/5, and it is only after 2 years, to be exact, on 15/5/17, the defendant number 1 woke up to the fact that the restoration application filed by the plaintiff is still pending hearing. It is if the learned counsel for the defendant number 1 was more vigilant, she could have immediately filed her show cause and proceeded with the hearing. But the same was delayed and show cause filed till 13/9/17. Hence, the defendant number 1 is at fault. Now, the fault has been now put on me, on the defendant. The plaintiff has shown a keen interest to pursue the instant case. The point of limitation, which was raised by the defendant number 1, cannot be considered because it was due to her fault that the instant application was heard after a period of 3 years since the time the restoration application was heard. So the reasoning of the trial court is that the point of limitation should not be considered because the application is being heard after 3 years. That's the reasoning of the trial court. Whereas the application for restoration is after 2 years. That should have been the consideration, not that it was heard after 3 years.
Yes, of course.
So she said limitation is not applicable. In the light of the above observations, I am inclined to allow the suit and shall proceed on merits. Now, on appeal, my lord, we filed an appeal against this order. Lordship will come to page 28. Because the delay, my lord, it appears there were many defendants in the suit.
Yes.
So after it was dismissed and they filed a restoration application after 2 years, so notices were issued to all the defendants. It would appear. And some of the defendants appeared, some did not. But I did appear. I was there. So all this while, the notices to the other defendants was awaited. And finally, when they came and said, we're not going to contest the suit, then the application was heard.
Okay.
Well, I'll just come to the findings, because what the appellate court has done, just reproduce my grounds for appeal. Page 36. Second paragraph, Malab.
Yes,
This
is the order dated 28/2.
28/2.
Yes.
The operative portion is at page 36.
36.
Yes.
Yes.
Learned Senior Counsel so-and-so in his submission submitted that the plaintiff respondents have failed to appear before the learned trial court. Hence, the suit was dismissed by order dated 7/2/2013. It is also submitted that the respondent, after a lapse of 2 years, filed a petition for restoration of the suit without any application for condonation of delay. The learned counsel also submitted that the suit was restored back to file by the impinged order dated 17/10/2018 without considering the fact that as per the law of limitation, the period of filing such application is 30 days. The learned counsel also submitted that notices to all the defendants have not been served. Hence, the question arises as to whether the defendants have been prejudiced for not serving of notice. It is also submitted that the litigation has been proceeded for ages. Hence, the procedure of the suit shall be on the early basis. Learned counsel for the respondent, Shri so-and-so, in his reply, submitted that the defendants shall not be prejudiced in any way, as notice has not been served to them. Further, it is submitted that the respondent has given sufficient reason while filing the restoration petition before the learned trial court. More so, it is submitted that the law of limitation is not applicable to the parties who are tribals. The learned counsel therefore submitted to dismiss the instant appeal. Upon proper evaluation of the submissions of the learned counsel for both the parties and in relation to the contentions of limitation, I am of the opinion that since the District Council Court is governed not by the letter of the CPC but by its spirit, coupled with the fact that the respondent plaintiff in this instant case and in the trial court has shown sufficient cause for non-appearance. Further, the respondent, after filing the application for restoration before the learned trial court, have shown due diligence to proceed with the case accordingly, and the delay in filing the application for restoration was for the reason that the plaintiff respondent was lying indisposed. Further, as per, this is important, further as per Chapter 4 of the Law of Administration of Justice, Rule 34, speaks clearly that the Indian Limitation Act is not applicable in which either or both the parties are members of the scheduled tribe. Further, the suit before the learned trial court is yet to be stated, and that notice to other defendants, ejectment suit number so-and-so, has not been served in proper service. Hence, I am of the opinion that even if the suit is allowed to be restored, it will not prejudice the case of the defendants, as fresh notices may be issued by the learned trial court to all the defendants. Furthermore, considering the law of justice, equity, and good conscience, and considering the facts and circumstances of the instant case, the litigation has been proceeded for ages. Hence, I am of the view that irreparable loss and injury shall cause to the parties unless the suit is restored back to file, so as to enable the parties to contest the suit on merits. Therefore, in the light of the above observations and findings, in view of the fact that the learned lower court has allowed the suit to be restored back to file, I see no reason on my part as to why the impinge order dated 15/10/18 passed by the lower court should not be interfered. So, my lord, the appellate court has taken recourse to the Law of Administration of Justice in Meghalaya, Rule 34. Now, my lord is very well aware that the district council courts are governed by the 1953 rules. It would appear, although because the learned appellate court has not said under which provision of law specifically, has just said, it just stated that Chapter 4 of the Law of Administration of Justice. Now, my lord will come to the rules for, because district council compilation. The lordship will find Rule 34 of page 207, my lord, of that compilation.
Two zero seven. Very
completely different subject. Where proceedings are submitted to the District Council Court or additional under Rule 33, such court may thereupon pass such sentence or make such order.
Just a moment. These are the 1953 rules.
Yes, these are 1953 rules. And the appellate court had taken recourse to, let's say,
this rule.
If I'm saying that is not these rules, because these rules are part of the Rule 34 come under Chapter 3. We will also come to 205. This is Chapter 3 from Rule 29 onwards. 29, 30, 31, 32,
yes,
33, 32A, 33, and 34. Now, firstly, what I beg to submit, that is why while framing the issues of law, because this is a second appeal, I have drawn the court's attention to the fact that
These issues have been settled.
yes, my lord, order dated 24/2021, 24. For 2021.
Yes.
Lordship regard. Now, one of the first issue framed by this court is whether the district council courts are bound by the decision precedents of the High Court.
Yes.
Whether the decision rendered by this honorable court in Miss Review petition number so and so is per incurium in view of Rule 34 of the Khasis Aimship Administration of Justice Order 1950. Now, whether the Limitation Act is applicable to cases triable by district council courts, and whether the district council courts can take recourse to the provisions of the Khasis Aimship Administration of Justice Order 1950 in trial of suits cases. So, my lord, while referring to Section 34 of the Law of Administration of Justice in Meghalaya, the appellate court was actually referring to, because before that, my lord, in the Rules of Administration of Justice 53, does not say anywhere that the law of limitation is not applicable. Nowhere in the 1953 rules. It is only in Section 34 of the Khasis Aimship Order 1950 that you'll find from the Jensen compilation. Lordship, you will not find the 1950 rules there. It will be in the other compilation. 1950 Jensen somewhere. Ginseng somewhere.
1950.
Yes, the Khasis Aimship Order 1950. Sorry, Malada, I did not Ginseng somewhere. In the meantime, Malada, I'll just read what does Section 34 of the 1950 Act says. Application of the Indian Limitation Act. Except in so far as provided by these rules, the Indian Limitation Act shall not apply to suits in which either or both the parties are members of the scheduled tribes or tribes specified in items number 1 and 2 of Part 1 of the Schedule to the Constitution, Scheduled Tribes Order 1950. So 34 of the 1950 rules definitely says that Limitation Act will not be applicable. So the first question is that whether the District Council, while trying of suits, can take recourse to these provisions. Because, my lord, coming back to 53 rules, the 1953 rules.
The reference was made to Rule 34 here.
When she was referring to the Law of Administration, Rule Section 34, Rule 34, she was actually
referring to the 1950 rules,
not
the 1953.
Not the 1953. The 1953 rules, my lord, Lordship will see 1950 rules, page 214. Page 214 of this compilation. No?
Yes.
Now 58. What does Section 58 say? Repeal and savings. The provisions in the Khasi States Administration of Justice Order 1950, that's what we are talking about, published in the Government of Assam notification dated so-and-so, the Rules of Administration of Justice and Police in the Khasi and Jaintia Hills, published in the Government of Assam dated so-and-so, and the Assam Autonomous District Regulation 1952, published by the Government of Assam notification number so-and-so, are hereby repealed in so far as they relate to the matters dealt with these rules. Your Lordship, in Komarshan case, this issue also had cropped up. Your Lordship remembers, recollect. Rules of 1937 and 1950 have been repealed after the passage of this 1953. So after the passage of 1953, the district council courts cannot take recourse to a provision which has since been repealed by the Parent Act in 1953. That is one issue. The next question is whether the district council court is bound by the decisions of this court. Of course, one issue here has been framed. I don't think we need to go into that issue. Whether the judgment of the whether the judgment
now you have the factual aspect is over.
Yes.
So now we'll go issue wise
one by one. So my first contention is that the appellate court could not have taken recourse to 34. You're bound by the administration of justice rules where there are no provisions which says that the Limitation Act is not applicable in the 1953 rules. Now, number one is whether district council courts are bound by the decision precedents of the High Court. That is simple, definitely. It's a subordinate court of this court. They are bound. I don't think I need to say more. Now, number two becomes a little bit of a problem. Yes, whether the decision rendered by this honorable court in Miss Review petition number so-and-so is per incurium in view of Rule 34 of the Khasi Sameship Administration of Justice Order 1950. That is for them to argue on this point. Why per incurium, as per my understanding, is that when the judgment was passed by this court in that review petition, the court did not take into consideration the local acts, like 1950. 1950 says that Limitation Act will not be applicable. So in such a situation, my lord, the question may arise is whether the courts below, the subordinate courts, are bound by the decision rendered by this court or by the statute. That is the question. Because this court, unlike the Apex Court 141, plenary powers, what the Apex court says is the law of the land. But the difficulty would be when a judgment is rendered, even by the High Court.
That is always appealable.
Yes. That's the question, which whether the statute or the judgment. There are various Supreme Court. I think my friend will answer that question. Because according to me, yes, the lower courts are bound by the decisions of the High Court. The decision of the High Court is the Limitation Act is applicable to the entire state of Meghalaya.
You're going back to issue number one.
Yes. Hello?
I said you're going back to issue number one.
Yes. Now, whether the Limitation Act is applicable to cases triable by the district council courts, the answer also has to be yes, in view of the decision, the 2017 decision, which has not been appealed as yet or set aside. Now, interestingly, my lord, I've come across a decision of the Mizoram bench of the Guwahati High Court, because in that decision, my lord, even in our own decision, the entire case was based on the Mizoram, the Thangliana case, where the Supreme Court held that the Limitation Act is applicable to the state of Mizoram since 1971. Since the State Reorganization Act 1971. So the question before the judge in the Mizoram case is whether the Limitation Act is retrospective, whether it can be applied from the year 1971. William and Song has been held by this court and by the Supreme Court as a wrong decision. All along, as lawyers, as litigants, we have been following the principle, you're also very much aware, that Limitation Act is not applicable. So what has happened now, I'm not talking about this particular case, in other cases also, this issue has become a very intricate issue. It is not the fault of the litigants. It is not the fault of the lawyers also, because we have been taking the stand that Limitation Act is not applicable. So it would be very, unfortunate if the Act is made applicable to 1971. I think most of the suits in the District Council, especially, would fail just because on that issue. That issue is not here before this court, but I've seen decisions of the Supreme Court which says that although procedural laws are retrospective in effect, but if the effect is the substantial rights of the parties, then it has to be read prospectively. My friend may take may argue that when this particular case was heard, the order of the lower court was on 15/10/2018, and the impinge order of the appellate court also is 2020.
Yes.
So they cannot even say that when the matter was heard, Limitation Act was not applicable. Limitation Act became applicable in 2017. So they cannot take recourse to 34 or any other provisions of law, according to me, subject to what my friend says. And the last substantial question of law framed by this court is whether the District Council courts can take recourse to the provisions of the Khasi Sameship Administration of Order 1950. As I said, my lord, 1953 rules has repealed 1950. So there is no question that the District Council courts can take recourse to 1950. I'll place certain decision in judicial discipline, which says that the lower courts are bound to follow the judgments passed by the High Court, if at all is required, or I can reply later after my friend has, because these are facts which I've put before your lordship.
Yes.
In case it's required, I'll place these.
May it please your lordship.
Yes.
Here the case, my lord, is that ejectment suit was filed in 2011, and thereafter in 2013 the suit was dismissed for default of plaintiff, and thereafter, after a gap of 2 years, the suit was restored in 2015. After restoring the suit in 2015, the notice were issued, your lordship. I would like to take your lordship on page number 14 of the petition, of this appeal, your lordship. Page number 14, your lordship. Page number 14, your lordship.
Just move.
The first order of the District Council Court dated 15th October 2018. It says, your lordship, here, page number 14, the plaintiff then filed an application for restoration on 15/5/2015. Notices were issued to the defendant, but it was only the defendant number 1 and 8 who entered appearance, and wide order dated 3/8/2016, your lordship. Wide order dated 3/8/2016, the defendant number 8 expressed that she does not want to contest the suit. The notices to other defendants were also issued, but defendant number 2 to 14 refused to accept notices. Hence, the suit proceed only against defendant number 1 via order dated 25/10/2016, Your Lordship. Now here is it clear. The petition was filed for the restoration in 2015. The notices were issued, Your Lordship. Defendant number 1 and 8 appeared before the court of District Council Court. 2 to 14 they refused. 2 to 14 they refused, Your Lordship, to receive the notice. As such, the order and 8 also they came. 8 also she appeared and she said that she doesn't want to proceed with the case. So on 25/10/2016, Your Lordship, the order was passed that the suit will proceed with defendant number 1 only. 2016, Your Lordship. Till date, there was no show cause, there was no reply, nothing was filed by the defendant number 1. Now here the appellant. No petition, no application, no show cause, nothing was filed. Though I filed on 15/5/2015 application for restoration. But thereafter, the defendant number 1, they never prefer any petition, they never reply any show cause. But out of sudden, Your Lordship, after the judgment of the SELA committee, the judgment of the SELA committee was delivered on 12th April 2017. 12th April 2017, and thereafter the defendant number 1 came to file a show cause, Your Lordship, that is there on page number 26, Your Lordship. Annex 3.
Yes.
To the appeal petition.
Yes.
So page number 26, Your Lordship, Annex 3 to the appeal petition. It shows
Yes.
that restoration petition was filed on 15th May 2015. The case already proceeded by the order dated 3/10/2016, and thereafter, out of sudden, after the delivery of judgment of SELA committee, the defendant number 1 approached the court and said that yes, now I want to file the show cause. And the show cause was filed against my restoration petition, Your Lordship, on 13th September 2017. 13th September 2017, Your Lordship. After a gap of more than 3 years, 4 years, Your Lordship, more than 4 years. And that is why the learned court of District Council Court says that whatever the delay has taken place here, more than 3 years and 4 years, something like that, after filing the restoration petition, it is because of defendant number 1. Why they have not taken recourse, why they have not filed the petition earlier, when the restoration petition was filed in 2015. And the case already proceeded with against the defendant number 1 by order dated 3/10/2016. So once the case has been proceeded, Your Lordship, against the defendant number 1, whether again the hearing will take place for the restoration of petition or for the limitation or for any other things. And that's why.
But that was the observation of the court.
Your Lordship?
That was the observation of the court.
Yes,
that
Your
the
Lordship.
petition for restoration has not been heard. So it is.
No, it was not for the court. Court was aware. Court was aware. Copy was supplied to them. Everything were there, Your Lordship. Notice was issued. They have appeared. They have received the notice. They appear before the court. So they are well aware. They are well aware, Your Lordship. Defendant number 1, defendant number 8 appear before the court. Defendant number 2 to 14, they have refused to receive the notice, and that's why the suit was proceeded by the order dated 3/10/2016. After their appearance, court said that yes, defendant number 8 says that no, I don't want to proceed with the case. Defendant number 2 to 14 has refused to receive the notice, so only left with defendant number 1. So suit will proceed against the defendant number 1 only. That is the order dated 3/8/2016, 3/10/2016 says, Your Lordship. Now here out of sudden they came in 2017. When they got the judgment, the defendant number 1 got the judgment of Sela Action Committee that limitation is not applicable in Meghalaya. Now coming to the limitation, that judgment of the Sela Committee, Your Lordship. What the judgment of Sela Committee has handled? They have handled only two. They have taken up only two issues, Your Lordship. One, the notification dated 14/8/1966. The notification was issued by the then Governor of Assam that the Limitation Act is not applicable. So Honorable Court says, the Honorable High Court says that yes, that notification was issued by the then Governor of Assam and same has not been revived when the Meghalaya became state. Same notification has not been revived by the Governor of Meghalaya. Second was taken into consideration one letter issued by the Law Department, Your Lordship. One letter was issued by the Law Department in 1985 addressed to State Bank of India saying that Limitation Act is not applicable in Meghalaya. And the Honorable High Court said that yes, that letter has no value. These only two things have been decided in the Sela Action Committee. The judgment delivered on 12th April 2017, Your Lordship. But that judgment, that order of the Honorable Apex Court has not taken recourse, has not interfered with the rule, the laws applicable for District Council Court. Applicable for District Council Court. Your Lordship, District Council Court has been constituted under para 6th schedule of the Constitution of India and had the constitutional validity in consonance with Article 244 of the Constitution of India, Your Lordship. And to run the District Council Court, there are separate norms, there are separate rules, there are separate regulations. To regulate the law, Your Lordship, in the tribal area, even we have 1937 rule, we have 1950 order, we have 1953 rules, Your Lordship. And 1950 order has not been repealed. 1950 order, as per my learned senior was saying that 1950 order has been repealed after coming 1953.
But that has been stated, yeah.
But again, Your Lordship, the government of Meghalaya 1976, they have adopted 1950 order. There is a notification here, Your Lordship, that further to amend the rule for the administration of justice and police in the Khasi district and Jantia Hills districts and in Garo Hills districts, herein after referred to as the principal rules, and the Khasi CMC for administration of justice order 1950, herein after referred to as the principal order, had been received the assent of governor on 22nd December 1976. So it has been adopted again, Your Lordship.
That is where the actually...
Again it has been adopted.
Even, Your Lordship, in Commercian case, when Your Lordship was hearing Commercian case, now the question arose is how can 37 have already been repealed? When the government issued the notification, the latest notification making CPC, CRPC applicable, well, that is also very questionable because they have made it applicable to the courts, not to the area. What section 1 CRPC says that the state government has the power to issue a notification applying the provisions of CRPC to either Mokhar, Jayao areas or to the state of Meghalaya. But it does not contemplate applying the CRPC only to courts. Now you're in courts, CRPC is applicable, you go outside, then it is no longer applicable.
But it cannot be.
How can, my lord?
But see,
Courts
applicability.
are non-juristic persons.
Yes, they are.
Applicability can be only to the territory
Exactly.
or to the persons. Now when you say applicable to courts, what does it mean? While exempting the district council courts?
Applicable to courts.
In Meghalaya, the words used.
Yes.
Yes.
And with reference to the jurisdiction of such courts.
No. Exception has been made to the district council courts.
Of course.
Now district council court means the entire tribal areas except that European work.
There was that issue of lapse of jurisdiction, overlap of jurisdiction.
So 1950, as my friend is, they're still following 1950, 37. All these have been repealed, stood repealed. With the Reorganization Act, if you take the dicta of the Limitation Act, the Shela case, or of the Supreme Court, it would mean that after the State Reorganization Act 1971, all these rules have become, outdated. They've become, they've merged.
Today I have not brought the book, Your Lordship, that Justice Johnson one. There already it is there in the first page only is there, Your Lordship, that these 1937, 1950 order, 1953 has been adopted by the state government of Meghalaya.
Well, you see, Mr. Dingro.
Is there, Your Lordship?
If you talk about, let's talk about 1937 rules.
Yes.
If you say that it has been repealed, yes, the rules, the act, parent act has been repealed, but not the rules. Not the rules, as we know very well. See, by virtue of the Supreme Court's order. Now, and those rules are still prevalent even today as far as the, well, before the commission case.
Yeah, before the commission.
So what happened is, before that, they are applicable because in as much as judicial officers are functioning as per the rules,
because
the capacity of assistant to DC and additional deputy commissioner.
Because they have to function under some rules, as I understand. In fact, yesterday I was giving a lecture to the judicial officers also. The same issue came up. Now, under which rules do we function? Because 37 has been taken away. All along, the normal courts have been functioning under 37 rules. Because even the repeal provision of the 53 rules says, in respect, let me read, 58, are hereby repealed in so far as they relate to the matters dealt with in these rules. Because this is a larger issue, it is not confined to our case.
Yes, yes.
It has a larger implication. Are hereby repealed in so far as they relate to matters dealt with these rules. So it's only in matters dealt with these rules. So my friend is correct in saying that 37. So the question before this court is, in the absence of the 1953 rules, where Limitation Act has not been touched, not been said, anything has been said.
Nothing has been stipulated here.
So can the District Council Court take recourse to 1950?
50.
That is the more important question. Leave aside this case.
Last occasion I was arguing the matter, Your Lordship, and there I produced one notification. It was very latest notification. The appointment of deputy commissioner, the power of the deputy commissioner in the certain other districts, Your Lordship. And Your Lordship is well aware that appointment of deputy commissioner in a tribal area was done under Rule 1937, read with Act 1960, Your Lordship.
That of course.
So if 1937 had been repealed, then how the appointment of deputy commissioner till date in different district is being done under 1937, Your Lordship. So that 1937, my humble submission is that the 1937, 1950 order and 1953 rule has been adopted by the government of Meghalaya by 15th February, if I remember correctly, 15th February 1973, Your Lordship. It has been adopted, and 1976 it has been amended, Your Lordship. 1976 it has been amended and says that 1950, 1953, 1937 is applicable, and only what the amendment has taken place there in 1976, only that wherever the Assam, the governor of Assam, it has been changed to Meghalaya, governor of Meghalaya, all the district has been clarified here. That only the things has been changed. Rest the contents has been taken as it was in the parent rule. Secondly, your lordship, para 4 says that the district council court has to run under the certain provision of law and rule. And as per that only 1953 rule was constituted to conduct the business of district council court. If the 1937 or 1950 order or 1953 rule has been taken away and it has been repealed, then under which provision, under which rule the district council court is functioning?
53.
District court is functioning. And under which rule, under which order the deputy commissioner, now we are calling like deputy commissioner judicial. So deputy commissioner is functioning in the tribal area, where both the parties are not tribal. If 1937 has taken away, it means there is no rule for them. They are functioning without rule. Now secondly, my learned senior has taken the matter of Komarchan, your lordship. There, according to me, your lordship, as far as my understanding goes, the notification of the governor issued under para 5 of 6th schedule and the way the state is taking, interpreting, is a little different from my understanding. Because under your lordship, 6th schedule has been constituted, has been inserted in the Constitution of India as per the provision of Article 244 of the Constitution of India to safeguard the interest, customs, uses of the indigenous people. For that only the 6th schedule and the district council court and the has been constituted. And now there your para 5, the power has been given to governor to empower any officer as a judge of district council court and try the cases, but only those officers, those judges, your honor, which has been appointed under para 6, your lordship. Means who is the officer of the district council court, not like anyone will come and the governor will empower, your lordship.
I think that's a larger issue.
You are raising a
larger issue.
You are raising a submission which is won't be. See, I don't think it should be
That will be your lordship.
Because then your lordship
because
will have
if
to say that the judgment of
now
Shila Action Committee is wrong, which your lordship is not in a position to do so.
Exactly.
Now the only question here is whether the district council courts, while administering justice, can take recourse to 1950 rules, in view of the fact that in the 1953 Act there is no mention regarding limitation. Putting it simply, in fact, I'm helping my friend because this is a larger issue which will affect not only this case but other cases also. Exactly. If we go into all that, my lord, even then Komarchan case, your lordship had not taken into consideration Solampeo case, the Supreme Court, there is in 2020. That is a subject matter altogether different. But the short question here is whether Limitation Act as it stands today is applicable or not, and whether the district council is bound by the decisions of this court. I think that is we should stick to that.
Your lordship, this matter let it be come upon any other date, your lordship. I will come with the certain more notification and all, and I will compile the judgment along with the notification, and I will put before the honorable court beforehand, your lordship.
Yes, yes.
So it will be easy for the honorable court to go through.
Yes, because we are here to aid the court. In fact, as I said, this is a bigger issue, not confined only to this case.
Because you see, there's an interplay of so many rules and and act and statute, some of which has Mr. Dingdo has referred to, have been repealed, resurrected again. We don't know what is what.
I don't think this court would be in a position to give judgment on those issues because we are bound. I am bound. This court is bound by the.
Now, your lordship.
We are bound by.
Now, your lordship. Another problem has started. We are practicing in trial court and all. After the judgment of the Komarchan, now we started the problem that what is the actual jurisdiction, what is the actual area of the district council court. Even the deputy commissioner can try the cases. Deputy commissioner judicial is trying cases in different districts among the tribals, between the tribals. So now the slowly your lordship, like day by day, the district council or district council court and 6th schedule, para 4, para 5 losing integrity. Now it's about to disappear, your lordship. Only after I think after 4 or 5 years, only the building of district council court will be there, having no jurisdiction, having no power.
That's for the authorities to take a call. And I think the district council is working on it also.
Either that or it's for the bar to look into this.
Your lordship.
We are not talking
Not
about
only the bar, I think the
any
authorities.
particular section who is aggrieved. But the bar has to take a call on it.
The certainty should be there. But what is happening now is the district council courts are trying murder cases. Other district courts also are trying murder cases. Now these are same set of people, tribals, both victim and both the complainant. One set of persons are not bound by the CRPC. Now the persons being tried in the normal courts are bound by the CRPC. So these issues have to be addressed.
Those have to be addressed.
It has to be addressed, your lordship.
More often than not, it may not be by orders and judgment of the courts.
Yes.
It has to be by way of
many things are there.
by way of a discussion. You come up and policy has to be made on such issues, so on and so forth.
Actually, very big issue.
On the record, my lord, when Contempt came up, so there was a meeting of all the secretaries, in fact, the chief secretary and the secretary law and all that. So he said, how do you go about this? I said, you have one, you can take away the powers of the district council courts. And normally, then the district council court won't have the jurisdiction to try these cases, which was one of my suggestions.
You see, if the governor chooses not to exercise power under
Section 5,
para 5,
yes.
then
It's finished.
Matter finished.
The matter comes to an end. But by issuing one notification after another, it creates more confusion.
Even another issue we are facing, your lordship, like a tribe cases being tried by the session judges and chief judicial magistrates in other districts.
No sessions division.
But there is no session division created under section 9 of the CRPC, your lordship. Only one session division till date we have, that is Shillong. But the cases are being tried by the district and session judge. Cases is being taken up by chief judicial magistrate. But there is no session division.
These are practical difficulties we have faced. Anyway,
so like I said, it will be for the
bar also should take up this issue.
And
especially our learned seniors, your lordship.
Seniors or anyone who studies the matter. You have to go to it and you have to look to the intricacies of the whole the whole gamut. Otherwise, taking a piece here and a piece there will not help.
Because it may happen, my lord, if Kumar Chand case, although your lordship was there in the bench, is set aside by the Supreme Court. So all the proceedings which are going on now will come to a zero. I mean, it is a waste of time for the court, it is a waste of time for the litigants. So it should be set at rest.
Was any matter preferred before the Supreme
I
Court?
think the district council are in the process of.
Okay.
You also heard about that.
In that case, then the Supreme
Court. Not because they are against Kumar Chand, but to set at rest.
But yes, so finally let the Supreme Court decide. The Supreme Court is the highest law,
court, yes.
The highest court in the land, and whatever the Supreme Court says, like we say, 141 becomes law. It becomes law.
In fact, limitation also, the district council should have got.
Should have.
Because Mizo and Khasi are quite different. Mizoram was a union territory.
Yes.
Before it became a state. We have been taken away from Assam. The Organization Act.
Mizoram was not under 6th schedule, your lordship. There was no district council.
Exactly.
So that's why the limitation was not applicable there. But here we have the district council. We are being governed by 6th schedule.
Problem are politicians. They say yes, an important issue. After we go out, then they forget about much of it.
Deeply obliged.
On This matter is heard in part and will continue further on the next date.
2 weeks. 2 weeks, yes.
As prayed for, this is matter to 2 weeks.
But after 4th of September, Your Lordship, I will be out of station in between.
After 4th.
After 4th, Your Lordship.
That will be on. Today we are on.
September is there, Malab.
No, today we are on. We are 11.
Today we are.
After 3
11.
weeks. It will be after 3 weeks.
Yes, yes. Deeply obliged, Your Lordship.
Item number 10.
Yes.
Malad, this is a matter pertaining to promotion, Malad, of the BSF to the rank of 2IC, Malad. Second in command. In the BSF, they say that 2IC. Malad, here the DPC, Departmental Promotion Committee, that record has to be called.
Why?
To adjudicate this matter.
You are not privy to that record.
No, I am not.
Has this court passed any order in that?
No, my lord. We have prayed for the call for record. That is the DPC which is held. What are the finding of the DPC, my lord?
So,
The impugned
see,
order.
on the basis of the order passed in the DPC.
DPC, my lord. If I take my lords to annexure 9, my lord, page 46. That is the impugned order.
Section 9 is page 47. Yes.
My lord, here the
This is the impugned order.
Impugned order. There are two, because here I have been denied with the promotion, my lord.
Yes.
2 DPCs were held, my lord, on 6th October 2016 and 26th September.
You're reading Annexure 9, isn't it? Annexure 9.
Annexure 9, my lord.
This is superstition and promotion to the rank of.
Second in command and commandment.
So this was addressed
To the
HQ Special DG.
yes, yes, my lord.
By the commander.
By the commander.
Yes. Please.
And
What does it say?
it says that in the DPC you have not fulfilled the criteria, my lord. In the 2 DPCs.
Okay, so you were declared ineligible.
Ineligible for promotion.
You are serial number 4.
My lord.
So
I require for proper adjudication of this matter, my lord, DPC
So this DPC of 6/10
2016 and
26.
26/9/16.
Have you said anything about this DPC
Lordship,
in your?
I'll seek instruction, Lordship, in this matter.
You just note down these dates,
Lordship.
or whether you have said anything in your affidavit in opposition.
They have not annexed.
The counsel for the petitioner has referred to Annexure 9 of his petition, which is a communication dated
8th April
28 April 2017 by the commandant per PRS to the HQ special SPL DG EC capital WC close wherein reference was made to proceedings of supplementary DPC held on 6/10/2016 and another held on 26/9/2016 wherein the petitioner's name also figured in such communication. The Mr. Jahal, counsel for the petitioner, has submitted that the records of such proceedings of the DPC may be directed to be produced for this court for consideration, since the same are relevant to the issue raised by the petitioner herein. The counsel for the respondent, Union of India, has submitted that instruction will be sought for us regard this issue. Accordingly, on preamble, this is matter up to 2 weeks.
Lordship, 3 weeks, Lordship.
3 weeks.
Highly obliged.
Item number 11.
This matter may be taken up any other day.
Joint request from both the parties.
What is this matter about?
Well, this is regarding school, my lord, managing committee related and salary, my lord. So, and the private respondent, the order has gone ex parte, my lord. So the private respondent does not appear.
Only with regard to salary.
Salary, my lord, and certain dues which we have approached this honorable court, my lord. So the direction is given to the private respondent to release that amount.
Okay. On pre-made by the parties, this is matter of the
2 weeks.
2 weeks.
Second call from supplementary courses, item number 1.
May I please, Your Lordship? Your Lordship, on 12/1/2023, one Alto vehicle was intercepted by the Naka team at Umkyang, and I was one of the co-passenger in the said vehicle. 4 persons were arrested.
It's a private or commercial vehicle?
It is, of course, it is a private vehicle, Your Lordship. So while the vehicle was coming towards London by, I also boarded the car because I knew those persons who were there in the car. So driver was driving the vehicle and other 2 passengers, and I was there. So at the Naka point at Umkyang, the vehicle was intercepted and all the 4 accused persons were arrested. On search being made, from one of the co-passenger, some contraband items called Yaba tablets were recovered. It is of commercial quantity, and it is also allegation is that also alleged that some contrabands were recovered from the vehicle, also from the backside of the driver's seat. So, Your Lordship, matter was investigated, charge sheet has been filed, and Your Lordship, 2 accused persons, the driver and one of the co-passengers, has already been granted bail. My case is that, Your Honor, I am also similarly situated because nothing was recovered from my possession, and those to a driver who was the driving the vehicle, and the vehicle belonged to him. Of course, owner was different, but he was driving, he was possessing the vehicle, so he has been granted bail. and one of the co-passenger. So I am also entitled, Your Honor, on ground of parity, because I am also entitled for equality before law and equal protection of law. And the person whose position the contraband was recovered, he has not been granted bail. So only on this ground, Your Honor. Further, one of my other ground is that I am a sick person, and in the jail, some breathing disorder. I am suffering from breathing disorder. Twice I have been admitted in the hospital. The last admission was done in 6 June. And anytime I can get these recurring effects because I am suffering from epileptic disorder. It is a brain disorder and breathing disorder. So only on these two grounds, Your Honor, I am before Your Lordship, because my bail was rejected on the ground that I was conscious possession of the vehicle, whereas the other co-passenger and the driver were also conscious possession. If that is the case, only on these two, 7 months I am inside the jail, only on these two grounds.
Yes.
And there is nothing, Your Honor, CDR, nothing is there to connect me. Of course, I was there in the vehicle.
Lordship, as per the FIR Lordship at page 11, the name of the applicant is it starts with a drug peddler by the name of Abdul Mohit Bolbuya, Lordship, over there. He's the applicant and he's also the accused person here in Lordship, number one. And number two, Your Lordship, the order dated 4/5/2023 at page 34 and 35, Lordship. The contraband was seized from the personal possession and conscious possession of accused so-and-so and the petitioner, Lordship. And it was on this ground that the bail application was rejected. Conscious possession, Lordship, and personal possession.
So it was seized from his
Lordship.
person.
As per this order, Lordship, yes, it's from the personal and conscious possession of so-and-so and Abdul Mohit Bolbuya.
Conscious and constructive possession, that's
Lordship.
everything. But personal.
No, it is not recovered from my personal possession. They have said that it was, Your Lordship, page number, charge sheet, it is there. And even in the FIR, Your Lordship, it is there that yeah, in the FIR itself, on page number 12.
Charge sheet has been filed?
Yes, Your Lordship, charge sheet has been filed.
Lordship.
And 7 months I am
what is the
inside.
stage of the case?
Stage of
consideration of charge.
Fixed for CC, Lordship.
Yes. Only on the ground that, 2-person accused who has been granted bail, I have been denied because from my position also nothing was recovered.
But Lordship, at the FIR Lordship at page 12, one of the detained person, namely the applicant, the bail applicant herein, led the team during the search of the vehicle, and on his leading, one blue carry bag containing a packet covered with brown tape was found on the back seat of the driver. On opening of the same, 50 black pouches engraved with grape sign were found. On opening the pouches, a total of 10,000 orange tablets were found, which were suspected to be Yaba tablets, Lordship. It was on his leading.
Vehicle was not in my position. From the driver's back seat it was found. But of course here they have in the FIR the police has said that on my leading, vehicle is small vehicle, how I will lead, Your Lordship, because it was there in the driver's back seat. So my conscious position is not there in the material. In the charge sheet there is nothing that I was conscious position. And two accused person, co-passenger and driver, they have already been done. Only on that ground, Your Lordship. I have no other grounds. Only that I am suffering from mental disorder.
What is your evidence of that you are suffering?
I was admitted in jail, Your Lordship. From the jail only they admitted me in Jawai Hospital, civil hospital.
So you have been admitted and you're getting.
That is not very.
You're getting proper treatment.
I can get attacks, and sometimes it may be danger.
Maybe.
Only that one.
But that would be taken care of by the jail doctor.
Yes,
because they are
not continuous.
They are well equipped.
Yes,
yes,
that is what Your Lordship. But I may get any time. I may. Suppose if I will not be attended to properly and taken care of properly, then it may be dangerous for my life. That is the only apprehension I have.
But once you see in jail, there will be one thing you'll be much safer in jail.
Definitely, Lordship.
There'll be a number of person there.
Yes, sir.
There'll be sentries. There'll be guards and whatever.
Yes.
If suppose any attack come.
And doctors are available, Lordship. This is as per Supreme Court guidelines.
Yes. But on
it been some other disease or sickness which are
no, I have only breathing problem and yes. I have only two problems: breathing problem and epileptic, that is brain disorder.
What
And
is
on the ground of
what
parity,
does
your
this
lordship,
charge
only.
says about his involvement?
Lordship. Lordship, I'm relying mostly on their petition only because we are yet to receive any instructions whatsoever,
Charge
Lordship.
sheet I haven't closed, your lordship. Page number 20, that is recovery. Page number 20. I will just assist the honorable court. Page number 20, paragraph number 3. Consequently,
Yes.
notice under section such and such was issued to suspect 3 Ratikul Islam Barbhuya. He is also one of the co-passenger, such and such, and his physical body was conducted. In the process of conducting physical and personal body search of the suspect, Ratikul was conducted, and while conducting search on his left inner jacket, one packet covered with brown tape was found. And on opening the same, 10 black pouch was found on opening pouch. So from physical position of this accused, the contraband was recovered from his physical position.
Yes, yes, you are Abdul Mohit Barbhuya.
I am
Exactly.
Abdul. I am not Ratikul.
Yes. So consequently,
Yes.
notice under section
Was subbed. Yes,
issued
such and
to
such.
Abdul
Yes.
Mohit Barbhuya.
Barbhuya and such and such, and his body search was conducted.
Hmm.
In course of conducting physical body search of the suspect was conducted simultaneously. From your lordship, from my position, nothing was recovered. Now they go on to simultaneously the vehicle was also searched, and on his leading and showing during search of the vehicle, one blue color bag containing such and such was found from the back seat of the driver. On opening of the bag, on same 50 black pouches was found. So from my physical position, nothing was recovered. But they said that only allegation, there is no witness also. They said that on my leading from the driver back seat, some contraband was recovered. This is the only allegation. But whereas the driver who was in full custody of the vehicle, he has been given bail. And the other co-passenger who are also, this vehicle is private vehicle. It is not that commercial vehicle. All are known person.
Exactly, Lordship, because it is
So,
a private
my conscious
vehicle.
position,
And
how
on
it is
his
available?
leading only, Lordship.
No, that is the one line has been added. That will not suffice, your lordship. Had there been any case, I would have kept myself only in my personal body. I will not keep in the driver's back seat. There is no such allegation. Even the driver has not said that yes, I have kept, or no other co-passenger also. They have said that yes, I was the one who has kept the contraband. When other accused person,
Altogether, how many accused were?
4 accused
How many persons were arrested?
4 persons were arrested.
3 were released.
2 has been released. I am inside, and one from whose physical position contraband was recovered. He is not enlarged on bail yet. My bail may be considered, your lordship, because parity on the ground of I will cooperate with the trial. 7 months I have already, and there is no past criminal antecedent.
Heard Mr. S. Pandit, letter counsel to the petitioner, who has submitted that this application under section 439 is filed with a prayer for grant of bail. The petitioner, Shri Abdul Mohit Barbhuya, who is currently in custody in connection with the NDPS case number?
Criminal NDPS case 3.
Connection with criminal NDPS case number 3 of 2023, arising out of Lumshnong PS case number 4/1 of 2023 under section 22 under bracket C, small c, oblique 29 of the NDPS Act 1985. According to the learned counsel, the facts of the case is that on 12/1/2023, a vehicle bearing registration number ML 113832 with the petitioner and other passengers traveling on it was intercepted by the police at Umkyang, and on a search being conducted, contraband substances suspected to be amphetamine in the form of popularly known Yaba tablet was seized from the said vehicle and from the person, and from how many, from one person?
One person.
From one person traveling in the said vehicle. From one person. Accordingly, an FIR was lodged in this regard and investigation was launched, and also in the meantime all the persons who were traveling in the said vehicle were detained in custody. In due course, 2 of the co-accused persons were released on bail by the Penal Trial Court. The petitioner, it is the submission of the Land Council that the petitioner has approached this court mainly on 2 grounds. Firstly, that he is entitled to grant of bail on the principle of parity, inasmuch as when 2 co-accused persons have been enlarged on bail, it would be but proper for the same to be for the same treatment to be accorded to him in line with the provision as provided under Article 14 of the Constitution of India, read with Article 21 of the same. The second ground of appeal, second ground raised by the petitioner is that he is a sick person suffering from epileptic seizure, which would occur from time to time and putting his life in danger if proper treatment is not given to him. In fact, while he was in custody in the jail, he was referred for treatment to the hospital on 2 occasions, 2 or 3, on 2 occasions. It is therefore further the Learned Counsel has submitted that there is that the petitioner is innocent and the alleged contraband substance was never recovered from his possession. It is therefore appropriate that this petition may be allowed and that he may be allowed to be enlarged on bail with any condition that this court may deem fit and proper to impose. Ms. Gisela, the senior GA, appearing for the state respondent, has objected to the submission and the prayer made. Firstly, on the ground that the petitioner is very much involved in the case, in as much as the FIR, it was clearly indicated that he is a known drug peddler, and it was on his leading that the police has recovered the alleged contraband substance, which was found. Where were they found?
On the back.
Driver's back seat. From the back seat of the driver.
From the
back seat of the driver, Lordship.
Back seat of the driver in a
packet covered with brown tape.
In a packet covered with brown tape.
One blue carry bag containing a packet, Lordship, covered with brown tape.
Packet covered with brown tape, which on being opened was found to contain 10 black pouches.
50, Lordship, 50 black pouches.
50?
50, Lordship.
Here they say 10. Here your FIR says 10 black pouches engraved with grape sign.
Lordship, at page 12 it says 50, my lord.
The FIR 2000 orange pink color tablet.
And this is corroborated at page 20, the charge sheet, Lordship, 50 black pouches.
The FIR, it says.
Oh yes, okay. We'll confine to this.
Yes, Lordship.
Katakan ông kan unang ông 10 đây. Or 50 mo. Black pouches. Natang ông no. And on opening of the pouches, total number of 10,000 orange tablet suspected to be Yaba tablet was recovered. The learned senior G has also referred to the charge sheet file and has pointed out that in the said charge sheet, the investigating officer has clearly recorded the fact that the said seizure of the 50 pouches were seized on the leading of the petitioner hearing. It is therefore appropriate that this is not a fit case for grant of bail. at this stage. On consideration of the submission made by the parties, it is pertinent to mention that this is a case under the NDPS Act, more particularly under section 22C.
29.
22C
And 29.
and 29. 22C provides that the provision of section 22C would read as follows. 22C. Section 29 speaks of punishment for abetment and criminal conspiracy. As pointed out above, as noted from above, the seized quantity of what is the there is that table, isn't it?
That table schedule, you would say?
The schedule of commercial quantity is above.
This is for, in this regard, 50 grams, above 50.
Above 50 grams.
Above 50 grams comes under commercial quantity.
That's notification.
And the total seizure is
serial number 152 of the notification, specifying small quantity and commercial quantity.
152. 152 of what?
Serial number, you will see there is a notification specifying small quantity and commercial quantity.
In the act.
In the act.
It's in the act only,
Page,
Lordship.
page same, then 222.
Can you refer to what page?
My page is 222, you will see. As per this.
What serial number is it? Serial number?
Serial number 152.
152.
I'll just, let's see,
This.
Commercial quantity is
50 grams, Lordship. At the tables at serial number 152, Lordship.
Page 152.
No, Lordship, serial number. Lordship, I can give you my.
No, it should be here.
It should be there, Lordship. We can assist your Lordship.
I'll just.
Serial number 152, Lordship.
Serial. What is
152 euros?
I got it.
Under the NDPS Act, a notification has been referred to, which notification has specified small quantity and commercial quantity as regard the narcotic drugs and psychotropic substances, and at serial number 152 of the said table, amphetamine under the heading amphetamine, 2 grams constitute small quantity. Is it 2 grams?
Yes.
Lordship.
And 50 grams constitute commercial quantity. And what is the quantity?
Quantity seized is 1.055 kgs, Lordship.
1.2 kg.
The seized contraband substance in this case is
1.05. Where did you get 1.2? Lordship, as per the charge sheet, Lordship, it's 1.055 kgs, Lordship.
1.05.
At page 21, Lordship.
1.055 kg, which would constitute commercial quantity. Next, this being the case, the provision of section 37 of the NDPS Act as regard bail would come into consideration. It is noted that the petitioner has not preferred any specific application under section, nor made any prayer as regards section 37 of the Act. Be that as it may, the provision of the Act as regard bail would the provision of the Act as regard bail would lead one to see that bail where commercial quantity is where seizure of commercial quantity is concerned would always be taken in the negative sense, inasmuch as the court would assume that bail is not to be granted unless 2 conditions are fulfilled. That is, that firstly the public prosecutor is heard in the matter, and secondly that there are reasonable ground to believe that the accused person is not guilty of such offence, and that he is not likely to commit any offence if enlarged on bail. Again, as noted above, the charge sheet has been filed in this case, and the opinion of the investigating officer is that there is found a well-established prima facie case against the accused oblique petitioner, for which he is directed to stand trial. It would be a matter of evidence as to whether the petitioner, the accused person, is not guilty or not. Is not guilty or not. Would that make a sense?
No, Lordship, it's guilty or not.
Will not kunung to
Is guilty or not.
Is guilty or not? See, so many negatives are
Lordship.
However, at this stage of the proceedings, this court cannot or is not confronted with any evidence that there are reasonable grounds to believe that the accused is not guilty, that the accused oblique petitioner is not guilty. This being the case, this court is of the opinion that the petitioner has not been able to make out a case for grant of bail. The same is rejected. Before parting, it goes without saying that the complaint of the petitioner as regard his health condition is to be diligently taken care of by the jail authorities, and they are put to notice that the petitioner or being accused or any of the inmates of the jail are to be given priority as far as treatment of any ailment or complaint of sickness is concerned. With the above, this petition is hereby disposed of.
Much obliged, Lordship.